that word man or woman or other phrases representing the two opposite sexes are capable to interpretation in a gender neutral manner, it would open up a whole host of statutes and provisions to constitutional susceptibility. My Lord, your Lordship can skip that. 106. As far as the present case is concerned, the debates in Parliament during the framing of the Special Marriage Act and the Hindu Marriage Act 1956 are illustrative in this regard. The said debates clearly identify that the entire architecture of the statutes was premised on opposite sex marriages and the provisions surrounding the legal recognition of marriage, the succession amongst children, and other aspects, as are all completely premised on the legislative presumption of opposite sex marriages. The Parliament was aware of gays and lesbians even in 1954. However, it is clear that the Parliament took a conscious call of not mentioning them. It is interesting to note that the Select Committee on the Special Marriage Bill 1952 approved Section 4 of the bill in a form which did not use the word male or female and rather use the word parties. The clause is quoted as under, as per Select Committee. The parties have completed the age of 18 years. Each party, if he or she has not completed the age of 21 years, has obtained the consent of his or her guardian to the marriage. This is substantially what they want, to reinterpret. It was after a heated debate going on for days and days that Pandit Thakurdas Bhargav brought an amendment that provided for separate ages for boys and girls in the form of 18 years and 21 years. It should be reverse. Boys and girls respectively 21 years and 18 years. It is submitted that apart from the above, the debates clearly show the limited purpose behind the enactment and the clear, unequivocal understanding of marriage as an institution between opposite sexes. The speech of learned Minister of Law and Justice at the time, Sri Charan Chandra Biswas, is illustrative in this regard. The relevant portion of the debates are as under. Then Sri Biswas. Let me now refer specifically to some of the salient features of the bill. The first is, as I have already pointed out, marriage under this law will not require the parties to forswear their religion or to declare that they do not belong to any religion. Any two persons residing in India will be eligible to marry under the provisions of this law. It is permissive, no doubt, but it is compulsory only to this extent that if they marry under this law, the conditions herein laid down must apply. They must make up their minds as to whether they wish to be subjected to these conditions. If they do not choose to be subjected to these conditions, it is open to them to discard this and to marry according to the law which now governs them. That was, my lord, personal uncodified law, which does not prohibit LGBTQ plus marriages. Yes, except, my lord, in case of LGBT. Yes, my lord, Hindu Marriage Act prohibits. Yeah, my learned friend is right. The Act of 1872 applies to two categories of persons. Firstly, to persons who do not profess any of the major religions of the country, and secondly, to persons who profess the Hindu, Buddhist, Sikh, or Jain religions. The result is that this act does not permit any interreligious marriages unless the parties are prepared to forswear their religions. If they are Hindus, then both of them must be Hindus. If they are Buddhist, both of them must be Buddhist. If they are Sikhs, both of them must be Sikhs. And if they are Jains, both of them must be Jains, in order that they may marry under the Act of 1872 as it stands now. For the first time now, we are going to do away with all distinctions based on religion. The bill, if passed, will permit of interreligious marriages. Religious differences are put out of the way altogether. Government feel that the time has now come when religious differences should not stand in the way of a couple getting together. If they feel that their lives are cast together and the fact of their marriage should not in any way affect their religious belief, that is the main change. This is the legislative intent, my lord. Now, Mr. Sri Biswas, my lord, the underlined portion. Under the provisions of the original, I may read, I'll read the underlined portion. Under the provisions of the original act, none of the parties to the marriage could belong to any of the recognized forms of religion mentioned therein. Now, two persons, if they belong to the same religion, will be allowed to marry. But this privilege is confined only to Hindus, Buddhists, Sikhs, and Jains. That is because the main rights which were secured by this act were monogamy and divorce. The religions which were excluded already provided for monogamy and divorce. The Christian Marriage Act is monogamous and divorce is permitted. Muslims also have the right of divorce, though it is not monogamous. Kindly, my lord, turn to the next page. Lord, nothing may turn, my lord, on other debate. Srimati Reena Chakravarti, Mr. Deputy Speaker, sir, I do not propose to answer various things that have been said just now because I feel it is very difficult to answer people whose mind still remains in medieval times. It is even more difficult to convince anybody who thinks that he himself has the monopoly of all morality and everybody else who demands progress seems to be having some problem with someone, as we can read between the lines. Himself was the monopoly of all morality and everybody else who demands progress immediately should be dubbed as irreligious. We support this bill because the principles underlying this bill is progress. The entire idea is to have contractual form of marriage without the necessity of repudiating religion, which was necessary in the bill of 1872. This is the spirit, this is the heart and soul of the Special Marriage Act. My lord, next, my lord, speech by Sri Biswas, the Honorable Law Minister, is just to show that it was not a Brahmo Samaj oriented or Brahmo Samaj inspired piece of enactment. The Honorable Minister says that Brahmo Samaj, of course, is one of the major contributing factors, but not the sole contributing factor. Now, kindly come to my lord 57. PDF 57, my lord. My lord, at the third unnumbered paragraph, Sri Biswas. I was just going to read from the Act of 1872. It's, my lord, it can be avoided. My lordships may come to at the foot on homosexuality. Your lordship gets, my lord?
Yes.
At the foot, my lord, there is a title. This is debate dated 6th of September 1954. See, Raghava Hari, Penukonda. I do not wish to take up much time from the arguments that have been advanced for straying away from a thing that has been recommended by the other house. I am not satisfied that there has been a fair or a clear approach to the matter, but only there is an attempt to confuse the issue. One thing that I find is that this act was meant to afford an opportunity for advanced people, people with reformed ideas and people who are economically independent and have their own judgment, mature judgment about their course of action for the future. It is only for such people that this Special Marriage Act was intended. In the course of their arguments, members have been urging that the marriage age in the country should not be high. That is too old an age, and that therefore more people cannot come under this act. 21 and 18 was considered to be too old, my lord, in those days. It was also stated that this was only a permissive legislation to people who want to take advantage of it if they are in position to understand what they are about. You will see that the whole thing, you will see that the whole thing is made topsy-turvy. The idea was that the people who have attained a certain age, when they can make up their minds, nobody should interfere with their judgment. Now you want to reduce the age and put in a guardian. Why this spoke in the wheel? You know that this is permissive legislation, that marriage can be permitted between a person of one sex with any other person who is of other sex. This is what they understood, my lord, throughout. That is the heart and soul running, my lord, through the debate. Irrespective of caste, community, religion, anything. Then you want to introduce the advance, then the present generation which want to marry without the guardian's consent. I'm afraid this guardian's consent for marriage between people which you are introducing is going to be the cause of all that ineffectiveness of the legislation. Then Dr. Jayasuriya, I beg to move in page 9, line 43, after sodomy, insert with her homosexuality. But sodomy was a ground for divorce. He said, insert this also because this is prevailing. It would come that this is now quite prevalent. Mr. Iyengar, notwithstanding the fact that prohibited degrees have been brought down, I do not know whether the next generation may not say that a brother can marry a sister. According to Mandal's law, the idiosyncrasies of parents among animals will persist or generations. My friend Dr. Jaisurya will support me in this. Is this law to be ignored in case of man? A man must marry only a woman. He cannot marry a man. Is this all that counts? Then, my lord, on marriage between opposite sexes, Mr. Achyutan, I agree with that viewpoint. The girl and the boy must have sufficient maturity, sufficient age growth to understand the consequences by which they will be tied when they marry under the special law. So there is no necessity, no special ground, no coherent ground for saying that it must be reduced to 18. Moreover, according to me, why marriage means early responsibilities. There might be a sexual feeling, patience which will be there, and all that. We must try to restrain them. According to me, youngsters cannot think of marriage before 25 or 22. It is not simple matter. It is a serious thing, so that the age limit must be at least 21. There cannot be any reduction either in case of the boy or in case of a girl. Again, my lord, they were talking of opposite sexes. And Mr. Deputy Speaker, my lord, Mr. Chaudhary. Your lordships may, my lord, kindly come to, my lord, the bottom. My lord, kindly, no, my lord, just third para, my lord, from the top.
The floor of a house can't really.
At that time, solicitor,
Yes, my lord.
were there laws permitting same-sex marriages anywhere?